Cescon Barrieu Advogados. My name is Mariana Lombardi. I'm a partner here of the dispute resolution practice. And this is a very special week for us, for all arbitration practitioners, the São Paulo Arbitration Week. We have a joke that this is our fashion week for arbitration. So it's a pleasure to welcome you all. And we were given the hard task to offer an afternoon tea to our English friends. I hope we meet your standards. I'm not sure we have scone, but we have pão de queijo, which is way better, so make yourselves at home. And we are here with a stellar panel. Thank you very much for being here. We are going to listen to Marcelo Sacramone, Eleonora Coelho, Carolina Beneti, André Monteiro, Gary Birnberg, and Helena Abdo, who's also my partner here at Cescon. And we're going to talk about the duty of disclosure under comparative law. And it's very nice because we have practitioners that practice arbitration in Brazil, in England, and in the United States, so we can have a broader view on this topic, which is a very hot topic in Brazil. So I'm going to give the floor to Frederico, who will introduce the topic. Thank you very much.
Thank you, everyone. Welcome to all of you here in place, and also to all of you who are watching us online. My name's Fred Singarajah. I am one of the co-chairs of Lex Anglo-Brasil, who is the bilateral association for Brazilian and English lawyers. We have been organizing this event during São Paulo Arbitration Week. I'm going to say this is the third year. I could be wrong. Don't hold me to that. That's a disclaimer. But we hope to continue for at least another 3 years. It is organized in association with the University of London Queen Mary School of Law, and also with PUC São Paulo, which we have a pleasure to have been organizing this together for the years that we have. So I just wanted to thank the co-organizers, thank all the speakers, and thank Cescon Barrieu especially for hosting in this such wonderful building, which is almost as nice as my chambers in London. So I'm just going to kick off the topic because this is English Arbitration Day, and I'm a barrister, so I like to talk. I'm just going to set up a little bit and give you a bit of background on the topic from an English perspective, and hopefully that'll be things that all the speakers will then elaborate on and give their counter perspectives from their own jurisdictions. André giving the English jurisdiction perspective and developing further. Of course, he's better organized than I am, but I just wanted to give you a little bit of background. So I'm going to really do it on kind of 3 parts. First of all, the current position vis-a-vis our Arbitration Act, our Lex Arbitri, and then because we are England and Wales as a jurisdiction, the common law position, and then the consequences of the developments on the common law. And we have something called the Law Commission, who have proposed reforms to our Arbitration Act, and all within the context of the duty to disclose. So first of all, our Act, much like your Act, is from 1996, albeit that's not our first Arbitration Act. Our first Arbitration Act dates back to 1697, so we've been doing this for a little bit longer. However, really the section of our Act which used to and still is the Act which informs us in terms of duties of disclosure is not a section which expressly provides a duty to disclose, but actually that informs us what the test is for the removal of an arbitrator, and that comes under section 24.1, and the test is justifiable doubts as to, and it says his, although I'll also say or hers, impartiality. And that also feeds back to section 33, which is the primary duties of an arbitrator, and section 33.1a imposes a positive and mandatory duty on every arbitrator to act fairly and impartially. You may note that I've used the word impartiality and impartially. We do not have a requirement for independence under the English Act, and that is a conscious exclusion by Lord Savile and those who created the Arbitration Act, who drafted this version. And that's because we think independence causes more challenges than it helps. It's really impartiality which is at the center of whether or not an arbitrator should or should not act improperly. So that's the current legal basis under the Lex Arbitri. Then we come to a test, and our test comes from the common law, comes from a case called Porter and Magill, which was in 2001, and it was the then United Kingdom House of Lords. So the citation, if any of you want to look for it, is Porter v. Magill, 2001, UKHL 67. And what the test is, as you'll all know, it is not necessary under English law to prove actual bias. You have to prove apparent bias. And the test for apparent bias is whether or not a fair-minded and informed observer would conclude that there was a real possibility or danger that the decision maker was biased. That test is equally applicable to impartiality of judges as it is to arbitrators. There's no distinction. It's the same case law. And you'll note that it's an objective test, so different to some jurisdictions and indeed some rules, where it is whether or not the parties would get the impression there would be justifiable doubts that the parties would believe that the arbitrator decision maker is partial rather than impartial, lacks impartiality. It is somebody in their position. So there's no statutory express provision for a duty to disclose. However, in a recent case which you may have heard of, called Halliburton and Chubb, which was at the Court of Appeal in 2018 and then went up to the Supreme Court in 2020, it was actually in the Court of Appeal where it was decided that there was a legal duty to disclose any matters which would give rise to justifiable doubts. So that's a common law provision as it stands. And it says, and that was confirmed at paragraph 75 of the Supreme Court's decision. And what that actually says is that it is an implied term of a contractual relationship between the arbitrator and the parties, albeit it is not settled English law whether the relationship between the parties, institution, and arbitrator is wholly contractual or jurisdictional. I understand that in Brazil, it is jurisdictional. That's not the case in England, and I've argued both sides to what needed to fit my client's interests, as long as it was properly arguable. So much like confidentiality, the duty to disclose currently is a contractual implied term of that relationship. I just wanted to touch upon one little point before moving on to the reforms and then handing over to the panel, and that is the objective test. What Halliburton and Chubb demonstrated, if any of you are familiar with the case, there were a number of interveners in that case. I think it was the ICC and the Chartered Institute of Arbitrators on the one side, and GAFTA and the LMAA on the other side. And for those of you who may be familiar with Halliburton and Chubb, the facts very briefly are that the chair of arbitration A was appointed by an institution, and then they were appointed by one of the parties in arbitration A in arbitration B. And so there were issues as to whether or not, and the arbitrator disclosed the fact that he was involved in arbitration A to the parties in arbitration B, but didn't disclose retrospectively. So in that particular case, it was whether or not, if you're in multiple arbitrations with one common party, you ought to disclose that all the way down the line. And GAFTA and LMAA took the view that not really, actually, because we do so many and there's such a limited pool of arbitrators, if you had to do all those disclosures all the time, it would just be an impossibility. And the ICC and the Chartered Institute took the view, no, a fair-minded observer, independent observer, would see that as apparent partiality. Whilst in GAFTA and LMAA, they said no. And how can that be when you have one test? But actually what came out of Halliburton was that the test was sufficient and it is appropriate because it's a fair-minded, well-informed observer. So if you're in an LMAA environment where you know that this is the commonplace, then you should be well informed, and an objective, well-informed observer would feel that that's perfectly fine and you wouldn't need disclosure, whilst if you're in a more commercial arbitration where perhaps there's more of a pool, then that the same test applies for different circumstances. That was the conclusion of that. You can debate that till the cows come home. I'm sure our panel will. But I'll just conclude then with the Law Commission report, which just came out on the 6th of September last month, the final report. And there is a recommendation that there should be codification of an express duty to disclose. So that may well come in. It's a very short summary. Last thing I'm going to just say is statistics. So one thing you should observe is certainly the LCIA publishes, and on their website you can go and look at all the information about all the challenges to arbitrators and look at all the decisions and the rationale, so that's all public information. But there was also a study done by a firm, an English firm called Osborne Clarke, which was instigated by Sir Bernard Eder, who is a great former judge of the Court of Appeal and now full-time arbitrator, and it traced back all the challenges. They just went through all the case law for 10 years between 2010 and 2020 and looked at all the arbitration cases and the challenges. And I can tell you that in England and Wales, certainly in the commercial court, any challenges go to the commercial court in England and Wales. There have been 15 challenges over that 10-year period, 12 of which succeeded and 3 which lost. So on that note, I will pass on to Helena and look forward to hearing from the panel.
Thank you, Fred. There's a place here if you want to. Oh, there. So, welcome everybody once again to Cescon Barrieu. It's a pleasure to have you all here and also online. We know that we are being watched by a number of countries, especially in England, to our English Arbitration Day. We are going to have a very informal conversation. We have thought about a few topics under this hot topic that is the duty of disclosure, and I'm going to ask our panelists, our friends here that are so kind to share their deep knowledge on the subject matter, to present themselves, to introduce themselves. And by doing so, I would like to ask a first question. And you choose between you who is going to speak first. Please don't be shy. Ladies first. Ladies first. So, to our panelists, probably Eleonora or Anna, what, in your opinion, what is the content, what is the duty of disclosure for arbitrators? Why is it so crucial in arbitration, and what facts should be reviewed in your opinion?
You need a mic, or we can speak here with this mic?
I think so.
Yeah, everybody can listen to me. So, good afternoon. Thank you so much for the invitation, Helena, Frederico, and Mariana. It's a pleasure to be here. I'm also very pleased to be in the English Arbitration Day. I feel a little bit English now because my sister is married to an Englishman, so I feel at home. And I also would like to congratulate you for the premises. It's amazing. I used to say that this is the Fasano offices. I mean, compared to the hotel, it's really beautiful. So congratulations and thank you so much. And it's a very easy question, right? The one that Helena posed to me. What is the duty of disclosure? As Frederico said, of course, that you should disclose any fact that, according to a fair-minded or a third reasonable party, should be disclosed or should be considered as a conflict. But which are these facts? And which are the guidelines or the parameters that we should follow? And it may vary according to the countries and according to the cultures. That's why soft law is so important, such as the IBA guidelines on disclosure, and such as also the guidelines that institutions are nowadays creating, the ethical guidelines and parameters in terms of period, in terms of concrete facts, objective facts. But of course, this is very subjective issue, and it may comprise challenges and different point of views. And the importance, the second question that you posed, what is the importance of the duty of disclosure? Of course, it's allowing the parties to exercise their right of challenge, the right of knowing who is going to be the judge of that case. Some people ask, is this a constitutional duty or not? I would say, no, it's not a constitutional. The constitutional duty is to be impartial and independent. You know, to disclose is different than being independent and impartial. The mere fact that you did not disclose something does not mean that you are not independent and impartial. And Frederico was quoting here the Halliburton case, if I'm not mistaken, Frederico. And Halliburton, which is a very important case, internationally speaking, and even from Brazil in terms of reference, it considered that the lack of disclosure is only one element and not, the whole picture. The observer and the judges and the parties should bear in mind other issues, such as the behavior of the arbitrators, such as the relevance of the case that was not disclosed, such as how serious was it something really, I would say, far away, or something that the arbitrators thought that the parties might have known, such as the case that you mentioned. For instance, in Brazil, we had a case very similar to Halliburton with an opposite decision, the Fazon case. The arbitrator did not disclose that he was sitting in one case with the same party and the other party, and then the Tribunal de Justiça just set aside the award as if the duty of disclosure was an objective failure and like a constitutional duty, and which I don't agree. So that's my view.
Thank you. I think you can hear me if I speak loud. The microphone is not going to change, and I hope everybody who is following us online can. Thank you very much. And that's what I was going to ask, and you just answered to give us an example, because we have a lot of students here in the room and probably watching us, and maybe they don't know what kind of facts could be could possibly in the end compromise or not, what kind of facts should be disclosed and which disclosure, non-disclosure, would compromise the impartiality or independence of the arbitrator. So, Ana, would you add anything?
Yes, yeah, I'd like to add. My name is Eleonora Beneti. First of all, thank you, Helena. I feel like coming home because I was a partner of Cescon for 2 years, 6 years ago. It's been a while. I'm also happy this is organized by Queen Mary and PUC. Not Queen Mary, but I was a student at the University of London for a while as well. I did my LLM there, and also a student of PUC. So thank you very much for the invitation. It's an honor. I just like to add some things, and then coming back to Professor Luiz Olavo Batista. Once I did a course. It was a practical or course on arbitration with him, and he was like the professor who was organizing a small group for discussion. And he said, he gave us a question, and he said, well, we gave him the answer, and he said, have you checked again the law? Or have you checked again the rules? I said, no, so let's do it. And then I think words sometimes play tricks on you, because you don't remember exactly what the words of the law. So preparing to this, I went back to the law, to the Brazilian law, and also some of the rules that we use. And we have to be very careful here in Brazil when things are kind of going wild about what are the requirements for challenges, or what are the requirements to become, to sit as an arbitrator. And the Brazilian law states that the relationship, the arbitrators are not allowed to sit as an arbitrator if they have a relationship with the parties or the dispute. So this is the first thing. And also the Brazilian law sets, reminds us about the Code of Civil Procedure, but saying, look, those articles have to be applied whatever is possible, not exactly the list of the Civil Code of Civil Procedure has to be applied for that. And also on the duty to disclose, it says that the arbitrator has to disclose any fact that implies a justifiable doubt as to his or her impartiality or independence. So this is like the group of things that we have to consider when you discuss. And whenever I sit as those committees for challenges of arbitrators, I try to also go back to the law. We're talking about Brazil here. We go back to the law and go back to the standards that we are providing in the law. And they're pretty clear. Of course, there are discussions, but they're clear that we have to always focus on the dispute, always focus on the parties, always focus on whatever you have to disclose that provides a justifiable doubt to the parties. And this is not the parties, let's say, only possibility to judge as it's important or not to the parties. The judge has to analyze it in the eyes of the parties, of course, but in the eyes of thinking about the contents. And again, coming back to the discussion, we not all non-disclosure has to lead to a challenge with the arbitrator. We've seen in the discussions here in Brazil that the numbers of challenges are very low, considering the number of cases and the number of discussions or disputes that have been going on. So I just want to start with that. There's several other things that we can talk, but
how low are these numbers? We don't have statistics, but we have the numbers from the recent researches that have been conducted. How low? Because maybe people are not aware of how low these numbers are.
Yeah, we have here. Please.
Hi everyone, my name is Marcelo. I was former judge in the arbitration court here in São Paulo District Court. And actually these numbers were just revealed this year, but we don't have this particular question about the challenge of the arbitrator. But we can say that something around half of the arbitrations files actually have a sentence that was annulled the arbitration. But when you unconsider, or you do not consider the public health questions in this matter, when you some cases that were related to healthcare system, and in this particular matter, a mill, when you not consider this fact, the annulment of the lawsuits were something around 30% of the case. You said, oh, come on, 30% of the cases have...
But 30% of the case
no,
filed.
Yeah. 30% of the case, yeah, but only 10% of the files were related to arbitration discussion. So if you have 100 of arbitrations files, you have something around 10% of lawsuits in the court. Of this 10%, just 30% or 3.5 were actually ruled against the arbitration. So the percentage of the cases were really tiny. In this particular case, 3%, we believe that fewer than or a number lower than 1% is a challenge of the impartiality of the arbiter. So the discussion of this challenge is really, really tiny in Brazilian law, at least until now. But there is some kind of misguidance about the subject because in the state court, even nowadays, we have some kind of confusion between the duty of disclosure and some kind of impression of the impartiality of the arbitrator. So, as Ana was telling us, the duty of disclosure or the disrespect of the duty of disclosure is just one fact that should be considered by the judge when he is filing against arbitration. And this disrespect of the duty of eventually this disrespect of the duty of disclosure can change the burden of the proof if the disclosure was really about an important file or important case or the relation between the lawyers. This can even change the burden of the proof, but it's only a burden of the proof, and it's only one more proof that should be considered by the judge when he is judging if arbitration was made against the impartiality of an arbiter or something like that. But even nowadays, we have only the numbers of Brazilian court of São Paulo, and with just the rulings of CBAr, and even though it's something around, we can guess about 1% of the cases. So it's really a tiny number.
So 1% or even less, we don't know, but because we would have to have a clear statistical study about that, but of the awards they can be challenged under the lack of disclosure, but they in the end we know that these challenges courts do not consider these challenges enough to annul the sentence or the arbitration award. And you have touched a very important point, Marcelo. I have trouble calling him Marcelo because we know him from his surname Sacramone. So you have touched a very, very interesting...
My mother as well. Yeah.
So, Sacramone, not every fact that is not disclosed leads to the annulment or a conclusion that there was a lack of independence or impartiality of the arbitrator. If we compare, I know this is not in the script, but I know that you can help us understand. If we compare to how is it different from a judge in court?
Oh, it's a completely different point of view because, okay, the Article 14 of our arbitration law related or makes some kind of background that would be the same with the judge. So if a judge would be impartial or some kind of dependent, I could apply for approximation the same burden or the same causes to the arbiter. But we have a completely different background from the judge and the arbitrator. The judge was nominated by a public exam. He cannot relate it with lawyers or parties to be impartial, and there is a culture to the judge that he cannot be related, and he cannot be, for instance, in public events like this, because I could some kind of be related to the other parties or lawyers that could affect my judgment. So there is like a taboo that the judge should be in the castle without talking to each other. It's like this. When you have a completely different point of view about the arbiter, because the arbiter is nominated because of its knowledge in a particular field, because the relation that he can have about the subject, a material subject, we were just talking about now, a little bit before this lecture, this discussion, that was the arbitrator is nominated because he's an expert in some subject. So he's well known, he will give lots of lectures, he will be related, he will write papers about the subject, in some cases with the lawyers, because of course they are specialists of the subject as well, and he will be nominated by this. So I think the burden of the proof and the duty of disclosure about the arbitrator is completely different from the judge. First of all, because the judge would have this duty of disclosure in a file completely confidential with the court, without the parties even know about it, and could be refused by its own will. And the arbitrator would disclose all the facts to the parties evaluated with an objective perspective if it would compromise not the impartiality. I would say that a little bit less of the arbiter would be compromise the image that he is not impartial anymore. So I think it's deeper, but should be the burden of proof much more strict than the judge.
Thank you very much. And from an international perspective, then I address the questions to you, André or Gary. What do you think, what elements must be taken into consideration in the event of a lack of disclosure? What do you think could lead to the need of a judicial control? What is your experience on that?
Be happy to. Thank you, André. Thank you, Helena, Fred, Mariana, for the kind welcome, and to the institutions, the firms that you are representing here today. Before I answer the question, forgive me for this indulgence. Eleonora said something about a little out of place here. You may have gathered from my accent that I am an American presenting in front of you and with you at English Arbitration Day. There was, as was stated before, there was a question whether this session was going to be in English or Portuguese. I was kind of hoping it would be in Portuguese so that the English wouldn't criticize my American English. But here we are, so you have to live with me speaking in American English. On what had been stated before, everything that's been stated I agree with. The question is, how does this work in the application? You know, the idea of impartiality, the idea of a neutral third party considering it impartial, considering the question of impartiality. Well, who exactly is the neutral third party? What is impartiality, or what is bias? A quick word to state that in the United States, as in the UK, or I should say, excuse me, in England and Wales, the basis of the conversation starts with a legislative act. Ours is not from 16 whatever it was. That was before we were born. It's the Federal Arbitration Act of 1925, which has been revised. Now, the problem with what's stated in the Federal Arbitration Act, it speaks about impartiality, but it doesn't speak at all about what that means beyond a high-level concept. And that has been interpreted basically, and the legislators left this to the courts and to the institutions and to the practice to develop over the course of time. And in the United States, I'll get to your question, don't worry.
No problem. It's an informal conversation. You can be, because I know maybe you're gonna say something even more interesting than what I asked.
Okay, watch out, I respond in kind. Problem in the United States is that we don't have a uniform view, well, on anything. And you look at the way that different court systems have addressed this question and have addressed attacks on arbitrators for lack of impartiality or for partiality. And you see this mishmash of completely divergent, different things. And we're talking here, the Supreme Court, well, I should take a step back, and that the Supreme Court of the United States and here, forgive me, I'll go to my notes here. In 1968, made a pronouncement which led the analysis for other courts and the development of this question over the course of time. This was in a case called Commonwealth Coatings Corp. V. Continental Casualty Company. I can give the citation if people would like. But what they stated, and very importantly and very succinctly, arbitrators must avoid even the appearance of bias. Arbitrators must avoid even the appearance of bias. But what does that mean? And I'm going to bring up just one case because I think it's an extremely interesting case, which in fact incorporates Helena's question into this. And interestingly enough, it had to do with the practice group with which I'm associated with. It's no mystery. I'll reveal to all of you, I'm a member of a practice group called JAMS. JAMS has about 450 neutrals like myself, and it has essentially a structure in which neutrals, arbitrators and mediators, whom membership likes, whom they think could perform well and add to the practice, are invited to become a part of the practice. And then after a certain point in time, depending on certain other criteria, they may be asked to become partners. Being a partner requires an investment of capital, and the reward for that is a return on the profits of JAMS. And I'm going to drop a little piece of information here at the start because it will give some context to where I'm going with this. The owners of JAMS don't earn a lot of money for being owners. They just don't. They may make up their investment after 10 years, 8 years, something like this. But the people at JAMS, the partners at JAMS, are making their money by performing as neutrals, performing as arbitrators and mediators. I should state that part of the rules of our practice group is that we are prohibited from representing clients. So just again for context. So I want to talk about a case here in just a moment so I can give you the proper reference to it. It's known as the monster case. And it doesn't have to do with monsters. Again, ask me if you want the citation. It has to do with a beverage supply company called Monster, a dispute between Monster and one of its distributors, the distributors of the beverages. And I won't go into the details at all of the basis of the conflict, but there was ultimately the JAMS arbitrator, single arbitrator, who issued an award in favor of Monster, who was the claimant in this case, had disclosed at the outset of the case that the following: that he was associated with JAMS, that he had an economic interest in JAMS, that he had done a previous case, had sat as an arbitrator in a previous case in which Monster, the claimant in this case, was involved, and that in that case he had awarded Monster $400,000, which apparently within the industry and the circumstances is a sizable sum. It's a sizable sum. He also divulged that Monster was written in, or rather I should state that in the contracts for distribution into which Monster enters with its distributors, they're Monster's written contracts, the dispute resolution clause within those contracts specifies the use of JAMS. Okay, JAMS arbitrator, and JAMS is the administrative institution. Ultimately, what happened was they said the court, it went to trial court. The trial court, the arbitrator's award was upheld in appeals court. This is the important thing. This is the important point. And what they stated in their opinion was that the fact that this arbitrator had done a previous case, and it was a recent one, it was within 5 years, in which he gave a sizable award to Monster, was irrelevant. The fact that Monster was in, or rather that JAMS was in all of Monster's contracts and all the distributors knew that, was irrelevant. The fact that the arbitrator was part of JAMS and had an economic interest in the success of JAMS per se was not important, because that disclosure that he made could have possibly meant that his interest was in upholding the reputation and profitability, or I should say viability, of JAMS as an institution with which he is associated with. But what happened, what was important, was that the arbitrator did not disclose that he was a partner of JAMS, that he was a partner, that he got these residual profits, pennies on the dollar, at the end of each year because Monster had an ongoing relationship with JAMS, or JAMS had an ongoing relationship with Monster. And forgive me if I've gone into a bit of detail on this, but this is a very bizarre case. And there have been a lot of commentaries going through academic and practical journals and articles in the United States, and they basically all come under the heading of, should we all be scared to death about what we disclose and what we don't disclose, even if it was absolutely obvious and it made absolutely no difference? Here, it made a difference. So I hope I responded sufficiently.
You did more than that, much more than that. And it's a very illustrative example of the drama all this duty of disclosure means to us, and in Brazil and in our experience. So, André, please, what would you like to comment on this? Would you say, from your experience here in Brazil, but mostly in the UK, how do you feel about the is there any practical criteria for the establishing the duty of disclosure? What do you think should be disclosed or not disclosed? How to avoid this kind of situation that was described by the example of Gary?
And can I add?
Yes.
Is our Brazilian situation going the same as the international?
Yes,
scenario?
yes.
Are we different? Or you have the same issues as I see in the United States, in the UK, and other jurisdictions?
Yeah, well, thank you very much, Helena and Fred and Mariana for the invitation, and Cescon in general for hosting this event. It's a pleasure to share this panel with my colleagues. Some of them I know for many, many, many years, and more than 15
Don't
years.
disclose. Not a duty of disclosure.
I say more than 15 years, but I didn't mention who.
Some of them.
Yeah, some of them
Some
for more
of
than
them,
15 years. And thank you very much for all of you to make the time to come here. You know, this São Paulo Arbitration Week, it's a busy week for everyone. Things don't stop. You still need to reply emails, get calls from the clients, draft the pleadings. So thank you very much for making the time and being here with us. So I think, first of all, I think I would, as this is an English arbitration day, so I would like to share some data with you about arbitration in England, and then you address your question, Helena. So Fred mentions some of the data. I complement because I think it's very important when you are discussing comparative law to understand the context of the countries. Yes. As many of you might know, according to the Queen Mary survey in 2021, London was the top seat of arbitrations. 54% of the arbitrations in the world were seated in London, 54. And then Singapore, Hong Kong, Paris, Geneva, and New York. According to the ICC statistics 2020, Switzerland was the first one, and then France, and then United States, and then United Kingdom. And this is the ICC statistics. Yep. But if you look at the LCIA statistics, you're gonna see that in 85% of the cases in 2021, London was the seat, and in 2022, 88%. So if you add the ICC statistics to the LCIA statistics, it's gonna prove that this Queen Mary survey was right. London is the top one city in the world as a seat of arbitration. This is for historical reasons. The UK has connections with many different continents. These guys have been in Africa, in Asia, in Middle East. That's one of the reasons why there's a number of arbitrations in London. Another reason, and I think that's important for our discussions, is that the London court are perceived by international business people as a reliable court with a high level of predictability. And I think it's very important for our discussion because, as you maybe we'll discuss in more detail, I think my impression is that the Brazilian courts for many years they adopted a pro-arbitration approach, an arbitration-friendly approach, and things now are a little bit different, and it of course impact the image, how international players see Brazil, yes, and see Brazil, São Paulo, Rio, whatever, as a seat of the arbitration. One extra data that I think is important for our discussion is the number of times that an arbitrator is appointed / confirmed by arbitration institutions in London. So according to the LCIA statistics, in 2021, 68% of the arbitrators only received one appointment. 68%, only one appointment. 20%, only 2 appointments. And 7%, only 3 appointments. That's what I'm talking about context. It's a very different context. Here in Brazil, it's very different. I mean, I don't have access to the data of our main, most important arbitration institutions, the CBC, the B3, CSP. I don't have this data, but I would like to know what the percentage of 1, 2, or 3 appointments per year to the same people. Because, I think we are seeing this discussion about disclosure and challenges in partiality in the relationship between arbitrators and parties in previous cases, because there is a high concentration of cases in a few arbitrators. And I'm saying this, and I think nobody's gonna say the same thing here in this panel, because I'm the only lawyer here. I'm 100% lawyer. I'm not arbitrator. That's the data I want to know. So I think that the context in both countries are very different, and it will impact the way you're going to analyze both laws and how the courts are analyzing these cases. So another thing, and just to finish my explanation about our data, is that every year or every another year, the commercial courts in London, they release statistics about the cases. Basically the same thing that was Marcelo was explaining before regarding the São Paulo Court of Appeal. But I think there's a very different number from the Brazilian statistics. But between 2020 and 2021, in 74% of the cases before the commercial courts in London, not only related to arbitration, all cases, 74 were international cases. In 74 of the cases before the commercial courts in London, there was at least one international party, one party that was not incorporated based in the UK. I think that's a very, very different percentage if you compare to the Brazilian courts. Yeah, and explain again why London is top one in the city of arbitration. Because the courts are very used with international cases, with international parties, and they explain a lot. Well, regarding the criteria, that's a very difficult question, as we know, because it really depends on the facts. Yeah. But one thing that I would like to point out, and talking specifically about the Halliburton case decided by the UK Supreme Court 2 years ago, I guess. This decision was the base for the proposal drafted by the Law Commission, and they are saying we recommend that the duty of disclose should be based on what the arbitrator ought reasonably to know. It's not based on what he or she knows, but based on what he should or must or shall reasonably know. It creates a duty to the arbitrators to investigate some facts. These duties should be shared with the party, of course. The arbitrators cannot know everything, of course not. But it's not a passive behavior. They should actually try to find things when they receive the appointment to see if it will create any. And then there's another sentence that I'd like to quote. Just I want to avoid to say the wrong thing. Yeah. Okay. That might reasonably cause the objective observer to reach the conclusion that there might be bias or So they said the arbitrator should not disclose only what would cause the fair-minded and informed observer to conclude that there was a real possibility of bias. It's not what would cause, it's what might reasonably cause. So it's different again. And so this is the top one jurisdiction in arbitration, the city of arbitration. And the numbers of appointments to the same person is really low, which means that all of this discussion that we are having about disclosure, conflicts, links between lawyers, arbitration parties, is much lower there, because there are no repetitive appointments to the same person, to the small group of people. And even so, even in this context, they are seeing that what should have disclosed, what might reasonably cause the objective observer to reach the conclusion that there was a real possibility of a bias. Yeah. So I really don't have the answer to say which facts will cause this, might reasonably cause the objective observer. I don't have the facts because it depends on the case. But I just think, at least in England, they have been much more conservative than we are in Brazil, and they are not living the same context that we are living in Brazil. So I think this is basically the impression that many lawyers working in Brazil, they have. I think we should be a little bit more conservative in addressing the duty to disclose in arbitration. Thank you, Helena.
Thank you very much. I really didn't have access till now to this data. Very interesting. And I think Eleonora wants to
To give a little of emotion of the debate. Everybody was agreeing, so let's,
Disagree.
if I may.
Please.
I think this is the impression that some parties or the media may want to cause in the community, in the arbitral community, in the international community. Because the numbers does not show that. I was the chairperson of CBAr, and we have had the numbers showing that we have many different players being appointed as arbitrator, much more than abroad. It said that in the UK it's just a few, that people have a few cases, and when you were talking, I made a list of 11 arbitrators, international arbitrators, who have multiple appointments. Lucas Mistelis from UK, Eduardo Silva Romero, Colombia and France, Fernando Mantilha Serrano, Colombia and France, John Fellas, US, UK, Gabrielle Kaufman-Kohler, Germany, Switzerland, Janet Walker, UK, Australia, Gary Bourne, UK, Doug Jones, UK, Bernard Hanossio, Belgium, Albert Jan van den Berg, the Netherlands and Belgium. So just these names, everybody knows these names, and they have multiple appointments. I mean, they don't get a few. So what I'm telling,
Gabrielle is actually the top one.
yeah,
For years and
Gabrielle
years.
Kaufman-Kohler, she's
years and
amazing. She has several appointments. So what I'm trying to say is not that Brazil has a different pattern of conduct, and here in Brazil we have a concentration in the market, and in the world it's normal that the arbitral community is not that big, and it's not because it's closed, it's open, and the door is open, and we have here people from PUC and student, and it's open to the students. We organize the moods, the pre-moods, we sponsor, we open the doors, and of course there are few who will stay. They're gonna study, and they're gonna be good, and they're gonna be appointed as arbitrator, but the door is open. Everybody can be appointed as arbitrator, and what I'm telling is that it's a common it's a common fact that a small community is appointed, and the same arbitrators are appointed again and again because they're good, because they're renowned, they're writing papers, they're going to the conferences, they're experts. It's like a doctor of the heart, for instance. When the doctor of the heart is good, he's not going to have only he or she, the bias. She will not have only one heart to be operated like the arbitrator. I mean, if I'm good, I'm gonna be appointed. So I think that we should pay attention to the reality instead of the impression. I understand that, and I totally, how can I say, I understand that this impression is a real one. But according to the numbers, or at least the few numbers that we have, it shows that, it's just a small percentage, and that the numbers of the appointments are not exactly corresponds to the impression. And I took a few numbers here of international arbitrators to show you that also they're appointed several times. Just this.
Thank you so much. Now we're the heat is and then to increase even more, I'm gonna ask Anna. I know that you want to comment on something, but I'm gonna ask you. Okay. You have disclosed that you have been a partner to Cescon Barrieu 6 years ago.
Yeah.
So we have worked together, but you have never worked together with Mariana. And Mariana joined the firm this year. If you were appointed already in an arbitration in which Mariana is counsel to one of the parties, would you feel the need to disclose? The arbitration is an ongoing arbitration, probably just before the let's say after the main hearing and just before the award. Would you disclose this fact?
So
And
the case
if not,
went with her, this is what you're saying, the case came with her.
came with her too. Yes, she and you had, of course, everybody. There's a moment in which you disclose, but is it a duty that is pens until when? And in this case, I want to put it in the real world so you can see how difficult this is to deal with. Would you feel the need to disclose if the arbitration is already almost in the end, just because of this fact that the new partners have joined the firm in which you were partnered 6 years ago?
In this specific scenario, I wouldn't disclose because this is a public information. If you go to LinkedIn, you see me there, and 21 years also in Pinheiro Neto. So when I first started, of course, I was right after I left the firm, and 2 or 3 years after I left Pinheiro Neto, I would make a reminder, because it's two big firms, and the cases, we never know where the client is or the parties they're related to. I would not disclose, but make a reminder that I was a partner of Souza Cescon, and I worked at Pinheiro Neto. But after 6 years, and it's a public information, I don't think it would be necessary. And again, coming back to the public information, their information, they're pretty much there. If you go to whatever, LinkedIn, or you go to Lattes, or even if you type my name, sometimes you get the name of the firm that I was before. So I think these are considered public information, and public information shouldn't be something that would be necessarily disclosed by the arbitrator. Again, before, when I was first starting this, I would remind, because sometimes people don't see, but it was a reminder. I don't think it was my duty to say it.
Do you join your CV also, right?
Yes, I do.
That's what
But
Yeah.
again, the CV wouldn't be necessary as well. It's just public. If you whatever, you find it everywhere. And of course, it's 6 years. It's 6 years.
Now we are right where I was.
With all delicacy and respect, I disagree. I think that
But there's also, if you go, also there's the federal courts here made anunciados, which are kind of classify or directories or some
directives.
Sort of,
Some directives.
Guidelines is a good word. guidelines for related to this specifically say that public information it's not the duty to disclose is not necessarily public information. So this is one thing that I find public. It is there. It's there. If you type my name on Google, you find my whole my whole history. And it's also, if you go to the institutions here in Brazil, you find our CVs because they're there, they're online. So it's just go there and find everything there. Of course, depending on the case, I make a reminder. Maybe the parties haven't seen, but I don't think that's considered a duty to inform or to disclose certain information. And I had something to say. Oh, yeah. Okay. Yeah, I had something to say. Of course, I understand because we work in this environment, and we're talking about this all the time. But I don't see the courts changing too much their way of thinking about arbitration in terms of jeopardizing our security in the country. Bad decisions or crazy decisions, they come along in every type of jurisdiction, and in Brazil is no different. I see a little bit more concern on impartiality and duty to disclose, but I still don't see a danger. The numbers of arbitrations in Brazil, they're huge. I had lectures in Germany explaining to them why Brazil has so many cases. They were like, oh my God, I don't understand how you have so many cases. The numbers of arbitration, the growth of arbitration, of course, the numbers of problems also increase if you have that number. We have specific cases with specific interests that we know that, and bad cases usually get more publicity than the good cases. But at the same time, you see a strange decision, you see like 10 or 20 good decisions. So I still don't see like an alarm in terms of jurisdiction or safety in Brazil. Of course, we have to work, we have to enlighten, or we have to keep discussing things, but not yet a problem, a huge problem. Say no arbitration in Brazil. I think Brazil is still safe for arbitration. You disagree with me?
No, I think your reasoning is impeccable. Your conclusion, maybe not so much. But I think in the case that there's a specific carve-out legislation that specifically states there's no duty, okay, maybe you don't have to. But we should be looking at this, I think, in a more global context. The case that the arbitrator has to put on the hat of the possibility of being subject to the rules of diverse seats. That's number one, and to keep that in mind, not to build bad habits based on one jurisdiction. That's number one. The second thing that I'd say is that the arbitrator should take the attitude that discovering something which potentially could constitute a conflict is not the subject, should not be the subject of, or should not depend on the due diligence of one of the parties to look it up. That the arbitrator should just put it on the table, say, this might be relevant. I don't think it's relevant, but it might be. In fact, if I may, just a quick example. I was contacted about 3 weeks ago. There's nothing that I can't divulge here, by the ICC, New York office of the ICC, that stated that the ICC would like to consider me as a president of a tribunal for a specific case. Here are the parties, here's the jurisdiction, here are the attorneys, or here are the law firms representing the parties and the attorneys who will be working on the case. I said, I know that attorney on that side. So I wrote a letter to the ICC and I said, essentially, not essentially, I said almost verbatim, the following. Look, there's this attorney who's representing one of the parties, and I gave the name of the attorney, which I will not give now. I know this attorney. I've spoken with her on at least 2 occasions in my life, and once the 2 of us crossed each other on the sidewalk in the city in which we both live, and we said hello to one another. We simultaneously served as officers in on a certain legal organization having to do with arbitration, but we didn't have direct contact, really a direct contact, because our responsibilities were a bit different. Should I disclose this? And ICC responded to me, yes.
Oh my God.
You should disclose it.
Exaggerate.
Yeah, exactly. And in fact, I prefaced this whole description by saying, look, this thing is totally ridiculous. It can't possibly be a conflict. But I just want to be super sure, leave no stones unturned, make sure that, disclose it, Gary, disclose it. And, so this is very much part of my attitude, and I just want to bring on one other approach. I mentioned my practice group, JAMS, which is an administrative body also. The largest administrative body in the United States is the American Arbitration Association, with its International Court for Dispute Resolution as well. And some 15 years ago, I applied to be on their arbitrator panel, and they said, this is wonderful, but you have to do our introductory course. And I did their introductory course. It was a 3-day course. If I tell you the 2.5 days of that 3-day course was about disclosure and the importance of disclosure, and how something that you have absolute certainty that won't constitute a bias, you disclose it. You disclose it anyway, because if you don't, like my associate at JAMS, you might get, you might be crucified for not having disclosed it. Not for the fact that it happened, but for the fact that you didn't disclose it.
Yeah, but then again, I think the examples are different. I do disclose everything. I've even disclosed once that my brother-in-law worked in a bank that was like affiliate or something, and it was okay, and I served as arbitrator. I disclosed everything. I disclosed my father's previous professions. I disclosed my brother's office. I disclosed everything. But those are things that people wouldn't know, so you feel that you have to disclose. A previous job that you had for 2 years, it wasn't even that long, or in 6 years ago, and it's there, it's public. So again, I wouldn't say that it's a duty for me to disclose previous law firms. In the beginning, I would do it because their cases, their clients, and we never know the parties that are involved in arbitration. But I don't see that a previous 2-year position that's public, it's in my CV. I need to do a specific look. And it happened to me, actually. That happened to me, or in a case, I'm trying to remember if it was with me, but it was, of changing, of course, lawyers. That sometimes is a tactic that they do to try to eliminate the arbitrator. And they came, look, but there's something here that you should have disclosed. I said, it's there. It's right from the beginning. It's there. If you changed, you are now in the case. You should look back in the files. You continue to look back at the questionnaire that I signed. Everything is in there, and with my CV, with the participation in the firm. So I don't think it is something that I have to say. Look, now that I see the lawyers change, I have to disclose again that I disclose, or there's something that this information is in the files way back. I do agree with things like, for instance, you have a relationship, an academic relationship with people. People say, thank you, Anna, for all your help in this dissertation or this PhD thesis. I'm pretty careful with that, and I disclose. I know the lawyer's academic scenario. I know I've worked with this lawyer in another law firm on another case I had it as an arbitrator, but like public information, I'm not saying public information that is hard to find. It's public information that's pretty basic. If you see this, let's see whatever this arbitrator has done in her life, and it's there. So I wouldn't do a remind or do a new
Yeah, in fact, I didn't mean to say that you're obliged to do it.
Yeah, okay.
I meant to say that it's a good idea.
No, yeah. If I feel uncomfortable, of course I would do it. I normally take that position. Even some people think that we are disclosing too much here in Brazil, but I think it is. I agree with you in that. I think it's a good.
We agree.
I think it's a good position to do it, but I think it's public.
We are running out of time. I know that you want to continue debating, and we will have time for that. But I think, Cristina, did you want to? No, because you raised your hand.
Yeah, but she already
She ended up explaining. So let's have one more comment or a brief comment by you and another brief comment by Sacramone before we finish.
Brief comment. I knew you would disagree. The lawyers and the arbitrators would disagree, which is not a bad thing. It's good because then we can continue discussing. So I really think that this impression, it's not the impression of just a couple of lawyers. It's the impression of the whole market. And if this impression of the whole market that there are many arbitrators with too many appointments, it's probably because there's something that's real there. The problem is we cannot show it because you don't have access to the numbers. So the ICC and the LCIA, they ask the arbitrators to fill the form of availability, and right there, the numbers of arbitration that are involved. The Brazilian institutions, now I think maybe it was because of you, Eleonora, I think now CBC is changing it. But for many years, the arbitration institution resisted.
But you can ask.
And it's also on the website.
I know.
If it's important for you, you can ask for the arbitrator. How many cases do you have?
Yeah,
we just ask.
Yeah, we can ask. But why we're doing different things from CCA and LCIA? So you are shifting the burden to the lawyer to ask the arbitration. How many cases do you have? Oh, 20. I'm not sure if my client will like it. Well, why you just put in the form in the statement of availability as ICC does, as LCIA does, and let's just copy and paste the good practice. I don't think any problem in doing this. But the arbitration chambers resist for many years, and I'm very happy actually that the Council CBC is now taking this step further. I think it's an extra level of
governance. We're not asking how many cases.
Not yet.
No.
Someone told me that.
No. We're not asking how many cases.
It's in with the
it's
website.
It's only ICC who asks how many cases.
The LCIA as well.
ICC.
The LCIA as well, Eleonora. The LCIA as
Acho que o
well.
Marcelo Sacramone queria falar antes, assim, só não vou interromper.
No, go ahead.
Yeah.
Go ahead.
And
He was asking.
just to finish my comment, if you guys go to the ICC website now and put the numbers of all of these very important names that Eleonora mentioned, you can find how many cases they are appointed.
Incomes and subsons.
Yes.
Published
Yeah.
arbitral tribunals.
Yeah, I know. That's a great initiative. But you can find the number of ICC arbitrators they are appointed. You're not going to find anyone with more than 15 arbitrations. You can put all of these numbers. You're not going to find anyone with more than 15 arbitrations.
15 ICC arbitrations. Not 15 arbitrations at the same time. Unfortunately, this is something that happens because other people. But things are very concentrated sometimes. But
Just a short comment. The worst arbitrator I work with has only one case. No, it's very relative. He has only one case. He's a lawyer. He's a full-time lawyer. He does not have case for the case in which he acts as arbitrator. He's the worst one. So I think it's completely relative, the fact that the arbitrator has 15 cases or one case. Maybe you want an arbitrator because he has 30 cases and not only one.
I agree with you, but I don't have an
just-
arbitrator with 60 cases or 50 cases. That's what I don't want, definitely.
Is it?
You don't have to appoint the arbitrator, you appoint the one.
But the
who
other
has
party
one,
can
and then
appoint. The other
you
party
take
can
the
appoint.
chance.
The arbitration chamber can appoint. I don't have control of all of the arbitrators.
Imagine if we had a rule like that, a ruling that you cannot have more than X
Yeah.
cases. The court system would collapse because because it's the same. In this case, the judges in Brazil, they are so. Does it increase the possibilities of bias, or but depends, because depends on the actual relationship that there is between these people and the lawyers and everything. But Sacramone,
I have
please.
2 points of view. The first one is that I think the duty of disclosure is with the court and not with the interested party, because that's why I think public information should be disclosure, even though, because you have to disclose everything that could some kind of affect the impression of
Would
impartiality, even
reasonably-
if it's public. Oh, but it can be challenged by the party in the first point of view because the information was public. This is not the matter. I don't think the duty of disclosure has the relation with the challenge that the interest party can make. This is one thing. So I think public information must be disclosure, even. The second one is, I think it is what Eleonora was saying. It's a different point of view, and I can make a relation with the trustee nominated by the court in insolvency lawsuits. For instance, in this particular matter, is much more trustworthy. This trustee that was nominated by lots of judges to supervise lots of debtors, that the trustee that was nominated by just one, because this trustee was completely dependable of the debtor and the payment of the debtor. So it's much more partial in this particular matter to some kind of hold this reorganization lawsuit than a professional trustee that actually have lots of work, is not dependable of this party, and probably doesn't care a lot for this lawsuit. So doesn't matter to me how many cases the arbitrator has, but probably it's much more attention I would pay to the fact that the same law firm has nominated this arbitrator, and this arbitrator has probably some few arbitrations, but all of these arbitrations he is nominated by just one firm or by just one party and things like that. So I think the question has to be viewed in perspective much more about the dependence of the numbers, so than the numbers of the nominator.
So I knew this is a hot topic. That I think we could open to everybody to comment. Fred, I know that you want to comment, but another colleague raised his He raised it. You have raised first, right? And please feel free. We can debate here.
So I just wanted to say one thing. The number of arbitrations which any single arbitrator is involved in is precisely the dividing line between GAFTA and LMAA on the one hand, and ICC and CIR on the other hand, as interveners in the Halliburton case. LMAA has about 32 full-time arbitrators. They don't publish their statistics because they're an ad hoc arbitration set of rules. They're not an institution. But on average, from memory, LCA has about 700 to 800 arbitration new filings per year, ICC in London has about the same, and LMAA has about 2,500 on average, okay? And they predominantly go to those 32 arbitrators, some not, but predominantly those. The difference is that many of those, because there are short limitation periods in maritime arbitrations, are filed and stayed. And then there are either settlements or they never come back. But it's all about the impression. It's not about partiality, right? The question is the optics. And if you're in maritime disputes, you know that there are 32 arbitrators, and that therefore these guys have 200, 300 extant arbitrations. And that's what you get. And so this is where, when I opened the Porter and Magill test, I was struggling. You know, we sometimes call the Porter and Magill test the IFMO, the independent, fair-minded, objective observer. IFMO. IFMO has multiple personalities, because one moment he thinks 3 arbitrations is too many, and another moment he can think that, or she can think that 200 arbitrations is okay. But it depends on the context, and that's where it is. So I think the number of arbitrations is one factor to be considered within the context, and it can be and it can't be. And then there's another question as to the capacity of being able to do the competent job depending on the scale of that arbitration. And generally speaking, that's why I think in commercial arbitrations in England and Wales, we have much larger pool of arbitrators, and they do fewer. But that depends on the context. And Halliburton was about Bermuda form insurance, which is a very specific thing where there are very few people doing it. And Ken Rockinson, who was eventually named, who's a silk, was a silk in the English bar, was one of those very, 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 very popular insurance arbitrators, and that's where it came on. So I don't think that's settled. To me, it didn't settle the question of does lots of appointments, is that certainly disclosable, I would say, predominantly, on the face of it, for all the reasons that Gary said, and Sacramone, I'll call him Sacramone now, myself. But that's my personal opinion, and this is unsettled stuff around the world, I think. But
the barrister articulated my point very well.
Yeah.
I just wanted to add also on the point about the quality and time that an arbitration takes. There is much more of a drive towards efficiency in arbitration now. So knowing how many appointments are running in parallel would impact the quality and the time the arbitration also then takes from the institution's point of view. So do you want an arbitration in 12 months, 2 years? Or if they have 10 arbitrations running parallel, then you're waiting. You have to bear that in mind, and that's where quality comes in. And I just wanted to check, Andre, when you mentioned 1, 2, and 3 appointments, were they LCIA statistics?
Yes.
Yeah, so to the point that then I think you mentioned after was those statistics were only LCIA. Those individuals receive appointments from multiple sources. So it's slightly different.
Yeah, that's why we were not talking about the same base, the same number. And I know, but that's why in my example, I made it clear, because there's a problem here. Would it be, we don't have to leave room for abuse. This is something that we have to be very, I'm very concerned about this. And we see that these lawsuits, the challenging arbitration awards, are, and even for the percentage of cases in which they have a favorable ruling, we see that there's a lot of abuse, and how can we prevent this? It's not, we have to be careful, because if we set a criteria that the number of arbitrations is something that can lead to bias automatically, or any other thing, we have to examine the context, and I think everybody agrees with this. That's why in the example I said, in this case, a partner that came to the firm with a case in a very advanced stage, and if Anna was an arbitrator, in this case, and Anna was a partner here 6 years ago. I think the only one in the room who worked with you is me, and we
Nobody's here anymore.
and only for a few months.
I think it is important to mention the new guidelines of CBAr, the committee.
Yes,
Brazilian
yes,
Arbitration
very
Committee,
important.
in order to help arbitrators and parties regarding the duty of disclosure. Have you seen the guidelines? So CBAr stated that the duty to disclosure is limited to the parties and to the lawyers. If there are related parties, it is the duty to the parties to inform the arbitrators that there are connected parties to that arbitration. Otherwise, the duty of disclosures is limited to the parties in the arbitral procedure. So another thing, arbitrator may request that the parties clarify information in order for the arbitrator to disclose all the information. Also, the parties may present questions to the arbitrators, and public facts should not be disclosed. So whenever you say, here, we are applying the guidelines of CBAr, you know that public information will not be disclosed. So, we are applying a common guidelines. So it's here, it's there. The parties have the burden to inform about the facts that are important to the arbitrators to disclose. For instance, it's important for the parties to know how many cases the arbitrator has. Okay, so you ask that in that moment, in the beginning, and not in the end when you have an arbitral award against you. Now I know that you have 40 cases and you did not, you know what I mean? So
It's crucial, the timing of the challenge.
Exactly.
Exactly.
And that's a very important thing that she said and you said. The cases are coming after everything happened and someone lost. And the arbitration law has a provision, a specific one, saying that you have to do it right after you know the fact, like Article 20. And these guidelines of CBAR are very good at pointing that out.
Exactly.
Say, look, you shouldn't come up at the end saying the fact that you knew before, and now you have to you apply.
Because you lost.
Because you lost, and the courts in Brazil, even for other types of cases, are very, very strong in that. You just don't come with frivolous discussions or things that you knew before, and it's just showing you that right now.
I think there's a question there.
Nudity from the pocket.
That's exactly.
From the two of you,
There's no way to
raise the hand
translate
first.
Okay, so first of all, thank you for the very interesting discussion. I would like to know what's your opinion regarding sanctioning an arbitrator for violating the duty to disclose. Why is that? For example, the new rules of the Milan Chamber, I know it's not a huge institution, but they established that it's later found that the arbitrator failed to disclose something that should have been disclosed, then the chamber can refuse to allow the appointment of this arbitrator in the following arbitration. Or also if it's later found that the arbitrator did not disclose something that should have been disclosed, the institution decides to make a reduction on the fees of these arbitrators. How do you feel about this sanction?
Thank you for your question, because it was one of the questions I have thought, and I thought we wouldn't be able to address it. So, who wants to?
Yeah, I can talk. We were talking about it just before the discussion, that I would say that probably the duty of disclosure cannot be related to the annulment of the arbitration. So this is a completely different thing. If you do not comply with the duty of disclosure, seems like that is not enough to be considered impartial, so it will not make a ruling against the arbitration. From this point of view, I have to say that the duty of disclosure is a contractual duty between the arbitration and the arbiter and the parties. If this duty is not, if the arbitration doesn't comply with this duty, probably it has to be punished. How can I punish? this was the question that we were discussing, and probably one of the things is that, oh, I will cancel, or the arbitrator cannot be arbiter here anymore because he doesn't comply with the rules. I don't agree with the punishment of the fees because it not makes sense for me at least, but probably he has to be punished with some kind of suspension, or if the duty was really clear and it was not, he doesn't comply with it, he didn't comply with it, probably it could be not a part of the code anymore, the arbitration anymore, or something like that. So, makes sense as a contractual punishment from the arbitrators with the parties and with the arbitration.
If it's agreed beforehand, right?
Yeah.
If it's agreed beforehand.
Of course.
I think, may I?
Yeah, sure.
I think that like the responsibility of arbitrators should be in cases of gross negligence and fault. I don't say culpa. How do you say this in English? Fault? Negligence. Gross negligence and fault. I think this would apply to the duty of disclosure. And whenever there is a cross negligence, something that it's really, a close relationship with one of the parties or an economic relationship with the attorneys or the parties, and it was not disclosed, okay, I think you might have a way of searching to punish or repair of the damage. Exactly. But, in other circumstances.
But punished.
Yeah, exactly. In other circumstances, I think it would be very hard because, as we are saying here, see different perspectives. Like he's from the U.S. U.S. has culture of full disclosure. I think it's cultural. It's cultural. And Anna, for instance, said, it's a public fact. It's in my CV. It's very basic. So it's very hard when it's something very subjective. So.
I can just say one thing, which is there are two things about failure to disclose, I think. One is the impact on the arbitration itself, and the second is the disciplinary integrity of the arbitrator as an individual, and the sanctions might be for that person as opposed to the arbitration. So you can fail to disclose, it doesn't have a material impact on the award, and therefore the arbitration process integrity is maintained, but that person's name is soiled, potentially, right? So we've got the Vice President of the Brazil branch of the CIARB, and the CIARB is an organization that has its own ethical rules, and if you're a member, you can be punished, and the CIARB goes after members who have been reported, and they will discipline them internally. So unfortunately, being an arbitrator is a relatively unregulated profession across the world, and there aren't many institutions like CIARB, there's a few of them around, that you can be a member, and if you get an arbitrator who's not a member of one of those institutions, you're kind of stuffed, right? So it's relying on market reputation about reappointments, and lawyers will know about it, and we're all lawyers predominantly who sit as arbitrators or appoint arbitrators, and so it's a market, at the moment, a market regulated. But whether it's the role of the institution to discipline the second part, I don't know. I'd resist that. I think the institution's role is really to do with the first part, maintaining the integrity of the process and the award, as opposed to the individual. They can have a secret blacklist and never appoint them again.
So always appoint a Chartered Institute of Arbitrators member. Just to be sure.
Good idea.
Yeah, and Helena.
I wanted to.
Yeah, you wanted to comment on something.
So this is, so thank you for all your insights, very, very thoughtful, all of them. But we're thinking that as an arbitrator, so you have a duty to the parties. Okay, so I always think that. So I'm here performing a job because these parties agreed that I would provide a jurisdictional response for them, for their dispute. Okay. So I always like to disclose as much as I can, like all of you here. But a lot of things that you disclose are not really a reason to challenge yourself. So it's not really a question of impartiality or independence or something, but you have to disclose it. Okay, so what if a party uses that to challenge you? What do you think having in mind that the duty is for the parties to perform a good job for the parties, should that be a reason for you to resign, not to accept it, or just say, no, I don't think this is a reason for challenging, and I will wait for a decision of the challenging committee or whoever will decide about the challenge. So what do you think? So
I've seen that happen more than once. I think all of us have seen. I'm not going to answer your question. I just want to say that this is a sad situation because it is happening a lot, and it seems under this kind of I don't want this arbitration to proceed. I don't want the arbitration to go forward. So I'm gonna just challenge and make and then there's a point in which the arbitrator says, I don't need this, so I will resign.
There's another thing that I actually heard. I heard that the CBC, the Congress, another very, very important arbitrator, very, very important arbitrator said to me, I was challenged. I didn't think it was a valid challenge, but it was so aggressive. And it was such a work for me to answer. And then they came with another comment, and then we had to answer. And then it started affecting my impartiality. I was starting to get mad with this part, and it would affect my judgment at the end. So I resigned. That's another point.
So that happened to me already. So they challenged in such an aggressive manner, and I said, no, thank you very much. I don't want to go further.
Guerrilla tactics.
And I was
It resonated.
So these tactics are kind of abusive.
But when you don't, not always, it's not aggressive always. So let's face it. And many times the lawyers, they just want to know, they just want to have more information, and they think, oh, right, it's not so bad for you, but it's for me. So we challenge you.
Helena, so now it's my opportunity to agree with the arbitrators. Finally, I have one to agree with them. First, on the previous point about the liability of the arbitrator, I think Eleonora made the right point. I think it's only in case of gross negligence. Because one thing that's very important, it's not in our Arbitration Act, but it is in many other arbitration acts, is the immunity of arbitrators be held liable for anything that happened in arbitration. This is a very important guarantee to the arbitrators. And the second point about what Christina asked me, I've seen it many, many times, and I see many arbitrators saying, oh, I'm going to resign because I don't want to create problems in the arbitration. I don't think they should do that. If it's a frivolous challenge, you should say, no, I'm going to stay, this is frivolous. I understand that depending on the seat of the arbitration and depending on the court jurisdiction to then analyze the set-aside proceedings, it might be the best thing to do, because one of the duties, and I think is the most important duty of an arbitrator, is to deliver enforceable award. That's the most important duty of an arbitrator. So depending on the jurisdiction, if you see that the courts are not very arbitration friendly, maybe that's the right thing to do. But I would say, no, try. If it's frivolous, no, don't resign, because you're giving an incentive to this party to do it again, and the other party are going to wait forever for having an arbitral tribunal constituted and start the arbitration. Yeah, but just with these warnings, depend on the seat. If the court and the seat are not very arbitration friendly, it might be better to leave the case, unfortunately. Yeah.
One last comment from Gary.
Go ahead. And the challenge question, the aggressiveness of challenges, I think that's very interesting. If we take a step back. Eleonora mentioned the completeness of disclosure in the United States. It could be a cultural manifestation as opposed to here in Brazil. I don't discount that at all, but my analysis would be that we disclose so much because there's so many crazy challenges. And if you disclose, then they won't be able to challenge you on something which you disclosed, whether it's legitimate or not. So it's a protective measure.
But don't you think that maybe when you over-disclose, you generate the opportunity for a frivolous challenge? Because why is the person disclosing this really ridiculous? So it must have something behind it. So let's challenge. You know,
It's possible.
Yeah, but challenging for what?
I think we are never
No,
gonna
because
solve
like
that.
challenging, for guerrilla tactics, for creating problems. So the over disclosure should be avoided, in my view. For instance, I'm in a case in which the arbitrator says, "I am a professor at University X. One of the lawyers of the parties studied at University X, took the LLM, but was not my student." I said, "Really? Did you disclose that?" The lawyer X here, but he studied it, but he was not my student. Should you disclose this? So why are you disclosing? What's the point? You know? So I think that like people are getting crazy. I mean, we should not go into the madness. We should, my view, we should keep on disclosing the IBA guidelines and the other guidelines, international one, as you said, because otherwise it would be an incentive for the party to keep challenging and challenging and challenging. I don't know.
Does CAMC-CBC? Oh, I'm sorry.
I think Claudio
Claudio.
wanted to pose a question.
I have more than a question. It's like, I'm really happy to see that we have more agreement than disagreement, which is fortunate. But I do think that at some point we should get to the core of the matter. Most discussions revolve around what's the criteria for what's a valid challenge. And at some point, Frederico started saying that we should have the average business person, but the average bankrupt business person, they have a view which is different from the Fortune 500 average. And then we come to the Brazilian criteria, which is the eye of the parties. I mean, no one is half as partial as the parties. I mean, the parties are partial by nature. I mean, they're supposed to be. And when I see the CBAr guidelines, I see the view of the arbitrators, which I'm not sure it's the view, the most proper view. And then we have the institutions, and I'm not sure the institutions are impartial either. So what's the criteria? And then we have the criteria of the judiciary, which, as far as I understand, is the worst possible. So,
Not offended.
it's my view. And right now, in academia, we have a number of students working on teams related to arbitration, and at least half of them currently, they write about challenges and criteria for challenges. And they asked me, what's the criteria, which I don't know. I have to start by saying that I don't know. I think it should be somewhere in between, amongst all those criteria. I used to think it was common sense, but as far as I understand nowadays, there is no such thing as common sense. A word doesn't purport to have common sense. But I believe the most impartial view should be the academia. It's whatever in the classroom, I'm sorry, not at graduate, but mostly at postgraduate courses, whatever we find there to be the criteria, those should be, at least those are the closest that I can relate to. But once again, I mean, Do we have an academic guideline? No, we don't. So the court of honor remains uncertain. And this is not a question, but if you'd like to comment on it.
If it were, I would have to go to therapy. I'm not sure if I don't have to treat, to go to therapy because of this, because we're never going to find an answer.
Well, maybe we will. I mean, we have, as far as I'm concerned, we have awful projects of laws, and we have a supposedly a coming decision of the Supreme Court. I mean, we might as well not agree with it, but at least we would have a criteria, which will most likely will be criticized.
May I pose you a question? What do you think the guidelines of CBAr is the arbitrators do? Because people who work there, they're also from universities, they act as lawyers.
Well, I did participate in it. But I participated as an arbitrator. So.
But I mean, like, all the players were consulted.
Yeah.
So also about the IBA guidelines, and which is being reviewed. So the IBA guidelines is like, I know that it's impossible, we're humans, and it's a very subjective concept, you know, impartiality, and especially impartiality, independence is more objective. But I mean, it will never have like a straight answer, objective answer, but I mean, the most important is to have legitimacy. And I think that CBAR is a very legitimate institution, and it's very impartial in this sense, because it does congregate people from the judiciary branch, also from officers, from clients, even councils of companies, inside councils. So I think that this is the best we could get, but you know, as you say, if you have something better, let us know.
If I may, the question of the IBA guidelines came up, or the question of it, the topic of it. I like them. I like them not because they're definitive, not because we should base our judgment on them, but because the arbitrator should look at the guidelines, because it'll give contextualization as to what to think about. You know, use this as the starting point, not as the end point. Guidelines.
Guidelines.
So, thank you very, very much. It was a very, very interesting debate, in my opinion, and thank you, a very accomplished group of people to be here. And this is about having an English afternoon, so let's have some tea. We deserve, after all this effort. Thank you very much. And it's a good thing that we are going to have this recorded, so everybody can, at the arbitration channel, Canal Arbitragem, rewatch it, and many other questions may arise, and some answers too. Thank you very much.